Again, I'm Doug Yergin. Thank you for having me. And this is an attempt to just sort of summarize where we are at this point in time as it relates to this litigation. And I have up here, I have several boards that I want to use to attempt to explain this. The first one is a copy of the first invoice that was sent to the city of West Palm, and the invoice date being back in October of 11. And basically, the Office of Inspector General ordinance that was eventually passed by the county requires that the clerk send us bills 4 times a year. This was the first bill. And to make it as clear as I possibly can, this lawsuit is just about the bill and nothing else. The city's 14 municipalities have filed a lawsuit against Palm Beach County. And it's what we call a deck action. We are asking the court to declare the bill, and only the bill, to be unlawful. And we have taken the position, both in our pleadings and in our oral argument to the court, that this bill is actually an unlawful tax. And therefore, the court should declare it to be an unlawful tax. And in addition to that, not only have we asked the court to declare it an unlawful tax, we've argued that it is an unlawful reach into the home rule power of municipalities. Municipalities have home rule power that's established in the Florida Constitution and in the Florida statutes, particularly Statute 166, which basically establishes municipalities, tells us what our authority and our power is. And we've argued that the county does not have the right to force us to pay this invoice, that we have the responsibility and the right to maintain our own budget, and that's incredibly important to us. I have a few different blow-ups that I want to use this morning. The next one that I want to put up here basically is a history of the proceedings, just so we have a general idea of how we got here. If you remember, back in 2009, Palm Beach County adopted several ordinances. And those ordinances being one that created a new code of ethics, a commission on ethics to enforce the code of ethics, and an Office of Inspector General. Those ordinances only applied in the unincorporated areas. They were not county-wide ordinances. Well, in July of 2010, Palm Beach County adopted what we refer to as a ballot ordinance, which would place these ordinances on the ballot and ask all the county residents if they want this to be a county-wide program that would not only apply in the unincorporated areas, but apply within the municipalities. Well, in November of 10, the referendum was held and the ballot question was approved by the voters. Shortly thereafter, in May of 11, the county passed what we refer to as the implementing ordinances. Ordinances that implemented now county-wide programs, making these ordinances, again, county-wide programs, not just ordinances that applied in the unincorporated area, but ordinances that applied in the municipalities as well. Well, the ordinance specifically dealing with the Office of Inspector General, what we often refer to as the OIG ordinance, required the clerk to send municipalities a bill for a portion of the expenses of the Office of Inspector General. And in October of 11, the clerk did that. And that's how we got this bill, based upon that ordinance. Well, in November of 11, the plaintiff municipalities filed this action, this lawsuit, again, asking the court to declare the bill to be an unlawful tax, asking the court to declare that this was an unlawful action of the county as it relates to impacting our home rule. And it's the city's position that, again, this lawsuit, if we win the lawsuit, the Office of Inspector General continues. There's a severability clause in the ordinance. The Office of Inspector General continues. And what I've put up here for you is a chart of all the countywide amendments to date. And there have been 8 of them. And if you see, the last 3 are the 3 that I just spoke of. The creation of the countywide code of ethics, the creation of countywide commission on ethics, and 8, the creation of countywide office of inspector general. And the unique thing is about this list, there's only one of these programs that requires the county to send a bill to the municipalities. And it's our argument because the other 7 are consistent with law. The county does not have the ability to send us this bill. Again, it's an unlawful tax. It's an unlawful reach into our budgeting process. And if the cities prevail and the court declares it to be an unlawful tax, basically, this last ordinance will function like all the other ordinances. And I have also created a board to make it clear. Again, I put it, what the lawsuit is not. It's not against the Inspector General, the Office of Inspector General. I know I hear a lot of people say that. Well, the city's suing the Inspector General. We're not suing the Inspector General. We're not suing the Office of Inspector General. We filed a lawsuit against the county because it's from the county that we get the invoice. So it's not against the Inspector General, the Office of Inspector General. It doesn't have anything to do with limiting the function or authority of the Inspector General. This lawsuit is neutral as it relates to that. We're not arguing that she shouldn't have the authority that she has, or that the office shouldn't have certain functions that the office has. We're merely saying the invoice is unlawful. You can't send us the invoice. Again, it's not about challenging the necessity or usefulness of the Office of Inspector General. It's not about the budget. It's not about challenging the will of the voters. It's about challenging the invoice that was sent to the municipalities. And I have argued to the court that this particular lawsuit is a lot bigger than the ordinance that established the Office of Inspector General. This particular lawsuit is about what the landscape of local government is going to look like in the future. Does a county have the lawful ability to establish countywide programs and send municipalities the bills for those programs? Or do they have to fund the programs the way they have historically funded the programs, through the revenues they generate, through the lawful taxes that they generate? So again, this is much bigger than any particular ordinance. This is about how local governments are going to function in the future. So again, we've taken the position that the invoice is unlawful, that it's an unlawful tax. And this is another board that I showed to the court on this, that basically governments have a very limited way to be able to generate resources and revenues. And you know, basically, they can either charge a fee or they can implement a tax. Well, the courts, you know, look at these things very, very carefully, because the Supreme Court has specifically said that the Supreme Court recognizes that there's a lot of pressure on governments to have programs and fund those programs. But the Supreme Court of this state has said, but we're not going to allow the necessity of the program or the necessity to fund the program to outweigh the legality as it relates to how you collect the money. And again, we've taken the position that collecting the money in this case by sending us that invoice is unlawful. Again, you can have user fees, special assessments, regulatory fees. Basically, the county has argued in its pleadings, in an oral argument, that basically this is a regulatory fee. That we can send the municipalities a regulatory fee. We've taken the position You can't do that. And that the case law is clear. And again, I'm not going to cite cases to you, but I've cited cases to the court, Florida Supreme Court cases, that deal with these specific issues. And from our perspective, it's clear that it's not a regulatory fee. And I don't want to bore you, but I want to make it clear where we are and why we're here. Again, the county's taken the position that this invoice is a regulatory fee and we can do that. We've taken the position you can't do that. It's not a regulatory fee, and the courts tell us what regulatory fees look like. And these are the four elements or indicia of a lawful regulatory fee. The first one is the entity, the governmental entity that's charging the fee has to have the authority to do that. We've argued, and again, what I told the court is the way this works is one strike and you're out. Not four strikes and you're out. If you are the entity that's trying to gather the regulatory fee and you can't establish one of these, it's not a fee. It's therefore a tax. That's the way the court looks at it. The court looks at the fee, looks at the money that's trying to be generated and says, okay, is it a lawful fee? Because local governments can only generate ad valorem taxes. That's the only thing that the Constitution and general law allows us to generate. So the way the court looks at it is it a lawful fee? If it's not a lawful fee, it's a tax. And if it's a local government and it's not an ad valorem tax, you're out. You lose. It's unlawful. You can't do it. And again, obviously, this invoice doesn't represent an ad valorem fee. So, the first one is we've argued to the court, county doesn't have the authority to do this. The Constitution, the county has made the argument that, listen, basically we can do whatever we want to do. As long as general law says we can't. We can do whatever we want to do. We've taken the position and argued, well, no, you can't. The Constitution says that you can do whatever you want to do as it relates to your self-government. If the action is consistent with self-government. Self-government, nowhere in the Florida statutes, chapter 125, that defines counties, nowhere does it say part of that self-government is generating fees or regulating municipalities. Doesn't say that anywhere. So we've argued to the court, they simply don't have the authority to do this. Again, not that the Office of Inspector General ordinance is a bad idea, but you can't send us this bill. It's an unlawful tax. You don't have the authority to do it. Not only do they not have the authority granted to them, but we suggest that our home rule power, the Constitution, chapter 166, that tells us how we can function, how we need to manage our own budget, that the county does not have the authority to reach into that process and say, you have to allocate this amount of money to meet this program of ours. Don't have the authority to do it. So again, if the county doesn't have the authority to do this, they lose. It's not a regulatory fee, therefore it's an unlawful tax. No regulatory standard. The second element is that the ordinance has to establish a regulatory standard. I've argued to the court that all the ordinance does is establish the office of Inspector General. It tells, if you read each heading, if you read the substance, which I obviously have many times, it talks about her power, her authority, what she can do and what she can't do. There's no regulatory standard. The Florida Supreme Court has said a regulatory standard is the sine qua non of a regulatory ordinance. And if there is no regulation going on, it can't be a regulatory ordinance and you can't charge a regulatory fee for it. Her powers are investigatory. The ordinance does not establish in her any regulatory standard, or in this ordinance any regulatory standard. So again, no. Enforcement power, again, there's no enforcement power in the ordinance. If you take the time to read it, there's just nothing in that ordinance that the Inspector General can report things to other people. She can write reports, but there is no enforcement power specifically given to the Inspector General in the ordinance. And the last one is a commensurate charge, which is a pretty big deal. Because, again, the Florida Supreme Court has said if it's going to be a lawful regulatory fee, the amount of money that you're billing, the amount of money that you bill at any given time, and this is a quarterly bill, that amount of money has to be commensurate with some type of regulation that's flowing back in your direction. We've argued to the court that this is not commensurate by definition. The ordinance establishes this loader system where all governments report to the state what their total expenses are. So you take all the local governments in Palm Beach County, they all report that those total expenses. You come up with a whole. In the city of West Palm Beach's total expenses represent a certain percentage of that whole. That's the percentage we have to pay as it relates to the budget of the Office of Inspector General. It has nothing to do with regulation flowing back our direction. It can't be commensurate. In addition to that, the ordinance talks about a whole group of people that have to cooperate with the Office of Inspector General. And it's not just local governments. It's private contractors, subcontractors, whole group of folks that are in the same boat as the municipalities. It's only the municipalities that are sent an invoice. So it can't be a commensurate fee. So we have taken the position that it's not a regulatory fee. It fails at every single point, every element. It's not a regulatory fee. Again, not arguing that the Office of Inspector General isn't important, not arguing that the function and the role is not important, but arguing you can't send us that bill. It's unlawful. Have to figure out some other way to fund it, the way that you fund all of your other countywide programs. And that's basically where we are.